today we have invited Preeti Chodani ma'am, and you all have been introduced to her. She was one of in one of our previous classes. She was invited as a speaker. So I'll just give a brief introduction of her. Preeti Chodani ma'am is the founder and CEO at Sri Datta Law Consultancy. She is an IPR expert at SSIP. She is an Indian patent agent. She is Institute's Innovation Council MHRD expert. Then ma'am is president at Gujarat State IP Council at WICCI. Then ma'am is SSIP facilitator and a startup man. With this brief introduction, I would now request ma'am to take over the session. Over to you, ma'am.
Okay. Thank you so much, Selja, for this opportunity. And good to see you all again. So we'll start with that. I'm just sharing my screen with you all. Is my screen is visible, right? This publication and examination of applications.
Yes.
Okay.
Yes, ma'am.
Okay. So today, as the syllabus or the topics is given for the today's session, so we are covering the publication and examination of the applications and the anticipation, then the this patent of Addison and the divisional patent applications. So these 4 topics we will cover today, and we are going through the each and every details which are given into our patent law or the patent act only. So this can be helpful to you all for the patent and examination perspective also, right? So starting with the first one, publication and the examination of the applications. So for that, for the publication, the section number 11A is the related section. So the section 11A is related to the publication of the application. So this may be asked for your, if you all are preparing for the patent and examination. So these simple things may be asked in the MCQ that which section is relevant to the publication, which is relevant to the examination and all. So for the preparation of the patent as an examiner, first you all have to remember the hold the index we can say into this patent act and the patent rules. So the each section or the rule number equivalent to relevant to the which activity. So let's for example section 11A, which is related to the publication or the application. So first you have to remember all those things. So that may be helpful. There's all the things will be helpful for the your paper 1 of the patent as an examination, mainly for the MCQ related questions. So starting with that, the publication of the applications, in that the subsection 1 of the section 11 save is otherwise provided no application for the patent shall ordinarily be open to the public for the such period as may be prescribed, right? So the patent office have make some provisions in that before that time limit any application cannot be available to the public. So that period will be the 18 months in normal scenario if we are taking. So from the first filing date or from the first from the priority date within the 18 after 18 months any application will be published. That is the ordinary thing or the normal pathway. With that also one provision is that is the early publication. So if anyone wants to speed up their patent application in the form of the publication as well as the examination, so for that they can apply for the request for early publication. So if you are applying for the request for early publication, so the application will be published after the 1 month of such request. So generally the public after publication only any person can come to know whether this type of the invention is available in or published by the way of the patent or not. So before publication, nothing is available to the public. Then coming to the subsection 2 of the section 11A, the applicant may in the prescribed manner. So as you all know that as per the section 2 of the patent law, they have given the different definitions of the terms which we are using into the patent law. So in that the prescribed manner means in any particular prescribed form will be there. If you are filing any form, so that is known as the prescribed manner. So request prescribed manner request the controller to publish his application at any time before the expiry of the period prescribed under the subsection 1. So in the subsection 1 what they have prescribed is 18 months. So if before that if anyone wants to publish the patent application, so they can publish, but for that they have to file the request for early publication. For that, a particular form will be there, form 9, and particular fees will be there. For the individual, it is the 2500. So, and the subject to the provisions of the subsection 3, these are the provisions of the subsection 3. The control shall publish the application as soon as possible. So the as soon as possible means generally they have given the timeline that if you are applying for the early publication, then it will be published after the 1 month of that such request of the early publication. So in the first, they have given the basic normal pathway that with the after 18 months of the first priority, the priority date or the first filing date, application will be published. Then in the second, they have given the early publication provision. So if any person wants to publish before the 18 months, then any time before that expiration of the 18 months, that person can request the controller that please publish my application as early as possible. Then coming to the third, the every application for the patent on the expiry of the period in the one means the 18 months be published except in some case. So generally all the applications which are filed either in the provisional or the provisional to complete or direct complete, that will be published. But some are the exceptions are there. So which are those exceptions which in those scenario application will not be published. So in that one, the three clauses they have given, the three scenario they have given. So in which the secrecy direction is imposed under the section 35. As you all know that as per the section 35, secrecy direction is applied to any of the patent applications. Means any application which are come in the field of the defense or the things which are not the patent office is not discloses those things to the in the public domain. So those inventions are falls under the section 35, and those applications are not published in this ordinary period, means in the after the 18 months. Then second one is the has been abandoned under the subsection 1 of the section 9. So as per the section 9, subsection 1 of the section 9, every provisional will be, it's a must or mandatory to file the complete specification after provision application, and that period will be the 12 months. So if you are applying for the provision application, then within that 12-month period you have to file the complete specification. So if you have failed to file the complete specification, then your application provision application becomes abandoned. So if that is become abandoned, then that those type of the applications or the provision, we can say that only the provisions applications cannot be published. And in the third one, has been withdrawn 3 months prior to the period specified under the subsection 1. So before this, right? So this period means the 18 months prior to the 3 months, means at the 15 months, if before 15 months anyone can apply for the request for the withdrawal. So in some scenario, if people is working in that the particular field and they have applied for the patent, and in the during that work or the research work, they come to know that further more work is required, or the things which you have proposed into the patent application, that is not now the results from that proposal is not come out, and you have to work on another prototype or the proposal. So in that case, people will withdraw the patent application. So what happened that the things which they have mentioned into their patent application which not come into the public domain, and they can freshly apply for the another patent applications. So for that reason, sometimes people will withdraw the provisional applications or the complete specification. That timeline will be the 15 months, or we can say that as per the language of the law is 3 months prior to the 18 months or the period specified into the subsection 1. And subsection 4 of the section 11A, in case of the secrecy direction has been given in respect of the application under the section 35, right? So this is telling about the subclause A. Then it shall be published after the expiry of the period prescribed under the subsection 1, means 18 months, or when the secrecy direction has been ceased to operate, whichever is the later. So now for this different clauses, they have given the detail. So for the secrecy direction, there is no case like that the secrecy direction related application will not be published anytime. Right, but they can publish once that secrecy direction related direction will be revoked or the withdrawn by the government of India. So at that time, if that things will be withdrawn before the 18 months, then application will be published at the 18 months only. And if that is withdrawn after the 18 months, then that after the withdrawal of that or the cessation of that directions, that application will be published. So whichever later, that scenario will be applicable over here. Then coming to the subsection 5, the publication of the every application under this section shall include the particulars. Now what things will be published? Before that, they have given the different timelines for the early publication, normal publication, which are the exceptions are there. Now they are giving the details of which things will be published into the public journal. So the publication, as you all know, that every Friday, Patent Office will publish the applications or publish their journal. So that every application will be published in the form of the journal, and every journal will be published on the every Friday. Now in that, what that journal will be contained? So it contains the particulars of the date of the application, number of the application, name and the address of the application, identifying the application and the abstract. So title also will be there, and the basic details about the applicants or the application number and the filing date will be published in the journal on the every Friday. Then in the subsection 6, upon the publication of the application for the patent under this section, one is the depository institution shall make the biological material mentioned in the specification available to the public. So the depository institution means if any invention which are related to the biological science or the related to the biotechnological field. So in that, you all know that we have to submit that biological material or the microorganism sample to the depository institution. So the depository institution shall make the biological material mentioned in specific available to the public. So once the application will be published, after that only that material which are deposited to the depository institution, that will be available to the public. Then in the subclause 2, the patent office may, on the payment of such fees as may be prescribed, make the specification and the drawing, if any, of such application are available to the public. So if any other person wants to check, inspect those documents physically, or they want to inspect the hard copy of that particular particular patent application, so by paying such fees, some fees they have to pay, and after that a control will allow them to check those documents. Then in the subsection 7, on and the form of the date of the publication of the application for the patent and until the date of the grant of the patent in respect of the such application, the application shall have the like privilege and the rights as if the patent for the invention has been granted on the date of the publication of the application. So and provided that the applicant shall not entitled to institute any proceeding for the infringement until the patent has been granted. So what is the meaning of this subsection 7? They are telling that from the date of the publication, our legal rights will be started. But we cannot take any legal action or the legal suit. We cannot file the legal suit against for the infringement before the grant of the patent. So the rights will be started from the date of the publication, but that legal proceeding will be started from the after the grant of the patent. So from the date of the publication to the grant of the publication, a grant of the patent, in between, if anyone is using your patented invention and infringing your patent, so you can keep in mind that this person is infringing my patent application, and after grant you will file an infringement suit against them, and you can ask for the royalty or the profit of account from the date of the publication to the grant of the date of the grant. So in between the period in between the date of the publication and grant, you can ask for the royalties as well as the damages, we can say in the general damages which you have suffered because he or she is using your patented invention. So that damages you can claim from the date of the publication, but legal action will be started only after the grant of the patent. Then provided further that the rights of the patentee in respect of the application made under the subsection 2 of the section 5 before the 1st January of the 2005. So this is related to the mainly black box application or the exclusive marketing rights, EMR, we can say that. So that is specifically the provisions are for the pharmaceutical provisions. So if the things which are applied during that period, as of now, these type of the provisions are removed or omitted from the act. But if the application will be applied at that time, shall occur from the date of the grant of the patent, provided also that after the patent is granted in respect of the application made under this section, patent holders shall only be entitled to receive the reasonable royalties from such enterprise which have made a significant investment and were producing and marketing the concerned product prior to the last day of this 1st January 2005, and which continue to manufacture the product covered by the patent on the date of the grant of the patent, and no infringement proceedings would be instituted against the enterprise. So this is specifically given for the patent applications which are filed at the time of this 2005, nearby that, right? So in that case, the things will be started, rights will be start from the grant of patent, not from the publication date. And one more thing, in that case, they have to give the royalty in that form, and they can continue their work till the grant of the patent, and after the grant, they have to stop. And before from the publication to the grant period, the person cannot take any infringement suit against them. This is specifically for the pharmaceutical products or the black box applications which are filed before the 2005. So this is all about the publication or the sections related to the publication. Now we are moving towards the rules related to the publication. So the rule 24 is visible to you all?
Yes, ma'am.
Okay. So the generally why the rules has been formed. So in the specific or in the sections, they have given the basic idea, or they have given the some of the timelines or the some of the provisions which may not be amended frequently. So those things they have given into the sections. And now the relevant forms will be there, relevant timelines. Then if any things which need to amend in the time basis, right? Some as you all know that for the examination, when we will learn regarding the examination. So the recently they have added the educational institution as a individual category or the natural person category, and education institute having a ability, they have a provisions to file expedite examination. So previously it was not there, but since last September amendment of the September 2021, this provision has been amended. So the things which you need to amend frequently, then the forms, then the flexible timelines which may be amended in the futuristic perspective, those all the things they have incorporated into the rules, because to amend the rules you have to only take permissions of the government and all, but only the state government or the patent office related provisions are okay. But for to amend this sections, you need to take a permission of the central government as well as the Supreme Court. So that will take a long time, and the something may be amended or not, may not be amended. So generally the rules amendment, if you will see when you are reading for the patent examination, so there are 1 or 2 times only the sections will be amended or the Patent Act will be amended, but the rules are frequently amended. Right. So coming back to the our topic, that the rule 24 that is related to the publication of the application, the period for which an application for the patent shall not be ordinarily to be open to the public under the subsection 1 of the section 11A shall be the 18 months from the date of the filing of the application or the date of the priority, whichever is the earlier. So the 18 months which I am telling you when I'm teaching you about the section 11A, right? But as such, there is no, this 18 months will be mentioned over there. So the timeline and the forms will be mentioned in the rules. So here they have mentioned that as per the section 1 of the section 11, which timeline in which the application will be ordinarily open to the public. So that timeline will be the 18 months. That can be start from the date of the filing or the date of the date of priority. So whichever is the earlier. Then they provided that the period within which the controller shall publish the application in the journal shall ordinarily be the 1 month from the date of the expiry of the said period, or the 1 month from the date of the request of the publication under the rule number 24A. So this is related to the early publication. So if you are applying, requesting for the early publication as per the rule number 24A, so in that case, your application will be published from the 1 month from that expiry of that period, or 1 month from the request of the publication. So now coming to the rule number 24A, which is related to the request for the publication or request for the early publication. So a request for the publication under the subsection 2 of the section 11 shall be made into the form number 9. So for the early publication request, you have to file the form number 9. If you are individual person or comes under the natural person category, then you have to pay the 2500 rupees fee with the form number 9. So this is all about the publication. So if anyone has any question in this publication, so you can ask. And after that, we will moving forward towards the examination. Anyone have any question in this?
Yes, ma'am. There is a question in the chat box.
Just a minute. Selja, how can I see the question, because my I'm sharing the screen now, so that chat box is not showing now.
No problem, ma'am. I'll read it for you.
As you can just read
Sure.
those questions.
In case of conventional application, 18 months will be counted from the date of filing in India or from the date of parent file.
No, in that case, the application will be published separately. That will be given into the conventional related application. That will let you know where, but that will be started not from started from the conventional application, because after 12 months you will apply into the India, right? So that window will be not acceptable for the conventional related applications.
Okay.
Any other question?
हेलो मैम,
Yes.
अगर मैं कंप्लीट स्पेसिफिकेशन 12 महीने के अंदर में अगर मैं फाइल नहीं कर पाया, मान लीजिए लेट हो गया एक आध महीना, तो उसके लिए क्या ऑप्शन है? मेरा वो डायरेक्ट
There is multiple
omitted हो जाए।
options.
अच्छा,
As per, you can refer that section 9. Whole section 9 is talking about this only. So in summary form, I can tell you that you can convert, you can post it. First option is that, so you can post it your application for next 6 months. So let's, for example, today you have applied for the provision application. Today is the 9th April 2022. So as per the normal timeline, you have to file the complete specification before the 9th April 2023, right? Now you are not completed your research work till that date, and you come to know at the in the March 2023, that you are not completed the work and you cannot submit the complete specification in the April month. So what you can apply for the post dating. You can post date your application up to the 6 month, next 6 month. So you can apply for the 1 month, 2 months, or up to the 6 month. You can post date your application.
12
So
महीने
that
के
can
बाद पोस्ट डेट करेंगे मैडम?
No, before completion of your that period. Suppose it's the 9th April 2022. So before that you have to apply for the post dating.
अच्छा, बाय मिस्टेक मान लीजिए मैं अगर भूल गया था, 12 महीने के पहले का डेट था, पोस्ट डेट का मुझे पता था, लेकिन दिमाग में उस टाइम था नहीं, तो 12 महीने मेरे खत्म हो चुके हैं, तो डायरेक्ट ओमिटेड कर दिया जाएगा अगर मैं पोस्ट डेटिंग फाइल नहीं करता हूँ, उसके बाद करना हो तो? ऐसा मैं बोल रहा हूँ।
So in that case वो फिर आप नहीं कर पाएंगे, because वो जो टाइमलाइन सब है ना, जो टाइमलाइन सेक्शंस में दी है ना, जो पेटेंट एक्ट में which are given into the section 9 and any other sections, that is the very stringent and the strict timelines. The timelines which are given into the rules, that we can extend those timelines, like to reply the examination report. So that is the 6-month timeline will be there, that can be extended for next 3 months. So total 9 months time with you, but the timelines which are given into the section, that cannot be extended by anyhow. So in that case, you have to file the fresh patent application, because never provisional will be published, right? So you can file the fresh application, but the drawback is that whole the 1 year period in between, if anyone anyone has published or used that your particular invention by the prior claiming or the prior use, so that can become a prior art for you. For post dating also, if you are post dating your application for the next 1 month, so that 1 month your priority will be shifted from the 9th April to the 9th May. now, so that in between from the 9th April to the 9th May, if any publication will be there or any patent will be published similar to your research work, so it becomes a prior art for you. So the post dating is generally risk taking, we can say that approach. If the we don't have any approach in that case, we are selecting the post dating approach. And if you have filed the direct complete application, let's for example today, and later on after 2 or 3 months you come to know that some of the research work you have to add in that, right? But that is the scope of within the scope of your originally filed application. So in that case you can convert as per the section 9.3, you can convert your complete to the provisional. So that from if you are converting your complete to the provisional, then from provisional to provisional, your time will be started. That 12 months time will be started from that provisional application which you are converting from the complete application. So the decision which you have to take, that you have to take before your due date has been completed. Otherwise you lose your priority and your rights provisional.
ठीक है मैम.
Any other question?
जैसे कि कंट्रोलर के पास टाइमलाइन, मतलब वी आर रिक्वेस्टिंग ऑन सम grounds of extension of some timeline, so the controller has the right that okay, he can allow it, but he can only allow those timelines which are mentioned in rules.
Yes.
That is what you were saying, no, just before some time.
Not there is no role of the
Like
controller
sections में
actually.
like section में अगर in general बात करें तो section के ना जितने भी timeline है, that controller cannot change, like even controller has not rights to alter those, like he cannot allow for those timelines.
Yes, and
for extension.
आप जब if you will see into the patent act ना, so you will find very less timelines, very less.
Yes.
Generally the provisional to complete the 12 months will be there. In some of the things, post dating related things, they have given 6 months. So the very less timeline they have mentioned over there, which are stringent and strict, which cannot be extendable. But in the rules, each and every timelines related to the section they have given into the rules. So in the futuristic, if some things will be need to be amended or need to be changed, so that can be changed into the rules, because the amendment in the rules is a little bit easier as compared to the Patent Act amendment. Anyone have any other question? So if there is no question, we are moving forward towards the request for examination, right? If anyone have any question, you can just write down in your notebook or the chat box. So we can also, I will give the answer later words also. So the coming to the this examination things. So in the Indian patent law, the patent examination, examination of the patent application is we can say that it's a deferred system. So in general, if you all have know that if you are applying for the any paper publication, right, research paper or the review paper, so they by default they are reviewing your paper and they are giving you the comments, and after that they will publish your paper. But that is the by default process. They are by default they are reviewing. But in case of the patent applications, there is no that by default system will be there for the examination perspective. So in that we can say that it's a deferred system. So if you are applying for the patent will be published. Then also you have to request patent office that please now take my application for the examination, and then only after that request for examination, your application will be taken for the examination. So that is known as the deferred examination system. So before moving forward to the examination portion, first we have to know about the request for examination. So the section 11(b) is related to the request for examination. So no application for the patent shall be examined unless the applicant or the any other person, interested person, make a request in the prescribed manner, means in prescribed form, for the such examination within the prescribed period. So no, as I have told that this is a deferred examination system in the patent law, so no application will be examined if you are not applied for the request for examination. Now, who can apply? So one is the applicant whose application will be there. He can apply, he or she can apply. And another is the any other interested person can apply. Now, what is the interested person as per the definition of the patent law? The person who is engaged into the particular field. Let's, for example, I am from the pharmaceutical field. So any other person who is from this pharmaceutical or the chemical background, that person will be act as an interested person for me, for my application, because we both are from the similar field. So that person interested or me means the applicant can apply for the request for examination. Then the prescribed manner that we will the details will be given in the rules in the rules also. But the prescribed manners means the form 18 will be used to request for the examination. Then prescribed period. So within the 48 months, starting from the priority date or the filing date, whichever is the earlier from that 48 months, or we can say that it's a 4 years, but as per the patent law language is a 48 months from the filing date to the priority date, whichever is the earlier. So that is the timeline. In between, within that 48 months, you have to apply for the request for examination. Otherwise, your application will be deemed to be withdrawn. Now, here we have one question that why the interested person file the request for examination, because request for examination is not the free of cost, right? We have to pay for, if an individual person will be there, then we have to pay the 4,000 rupees for that. So why the any person will file, if you are applying for the online mode, why the any person will spend the 4,000 rupees on your application, right? So that is a common question. So why this will happen, why interested person can apply for the request for examination? So let's, for example, I have applied for one patent application, and that patent application, in that I have mentioned one product, that is a product patent, we can say that. And let's, for example, Sailja is already working related to this type of the product, but not the exact similar, but some of the portions are similar or some of the parts are similar. Now Sailja is come to know by after the publication of my patent application. Now after my publication, Sailja is just checking how the patent application will publish, which patent application relevant to me and all, right? So the previously Sailja has a confidence that the no patent application is available or applied for the product for which Sailja is already working. Now she come to know that okay, this previous patent will be there who is exactly, or the some of the parts are similar to the my product which I'm already manufacturing and commercializing. Now now my patent will be granted or rejected. That is the interest of the Sailja, because the patent will be granted. Now at that time the Sailja has to stop the manufacturing and commercialization, and if not granted, it's rejected, then the freely Sailja can continue her manufacturing and the commercialization. So in that case, if I am delaying to apply for the request for examination, and due to the delay in the request for examination request means the 48 months, I'm taking the whole 48 months. So that 4 years Sailja having in between situation, right? So whether the patent will be granted or not, if that granted from the publication, the rights will be started. So if Sailja will manufacture and commercialize, then also she is in trouble and is stopping the that manufacturing commerce, then also she is losing her the monetary rights, right? Monetary benefits. So in that case, Sailja will apply for the request for examination because we both are from the same field. So she is the person interested for me, my application. So she will apply for the request for examination. So what happened? The application will be fast or the speedily moving forward, and the decision for the application whether it is granted or rejected, that will become earlier. So just to know whether this patent will be granted or not, because this is related to this her product, that's why she can apply for the request for examination. So that's why they have given here the option that the person interested can also apply for the request for examination. Then coming to the subsection 2, that is omitted, and subsection 3 of the section 11A, in case of the application in respect of the claim for the patent filed under the subsection 2 of the section 5 before the 1st January 2005, a request for examination shall be made in the prescribed manner within the prescribed period by the applicant or any other person interested. So this is related to the black box applications or the pharmaceutical related applications. So that is the provisions are now removed, but they have given the section over here. For that also the similar period is given, that 48 months, and the same form 18 we have to file. Then the subsection 4, in case of the applicant or the any other interested person does not make a request for examination of the application for the patent within the period as specified, especially in the subsection 1 and the 3, the applicant shall be treated as a withdrawn by the applicant. So if you are not applying, not requesting for the examination or not filing the form 18 within that 48 months period, then your application will be treated as a withdrawn, provided that the applicant may at any time after filing the application but before the grant of the patent withdraw the patent application by making the request in the prescribed manner. So any applicant at any time after filing of the application and before the grant, before the any time the person can apply the request for the withdrawal. Then second, in case of the secrecy direction has been issued under the section 35, the request for examination may be made within the prescribed period from the date of the revocation of the secrecy direction. So for the secrecy direction, they have given the separate provisions for the request for examination, because sometimes what happened, the secrecy direction will not be revoked till the 48 months. So if they are following the same scenario for the secrecy direction related inventions, then they will, that person who has applied for the patent application under this secrecy direction, those person is failed to file the request for examination and his application will be withdrawn now. But they have given the special provisions for the secrecy direction, and they have given that after the revocation of the secrecy direction, within the 6 months you have to apply for the request for examination. Then before taking this examination of the application, we will first see the rules which are related to the request for examination or the examination. So this 24B is visible, the screen of 24B. Okay, so a request for the examination under the section 11B shall be made under the in the form 18 within the 48 months from the date of the priority of the application or from the date of the filing, whichever is the earlier. In that they have given second provision, the period within which the request for examination has been under the subsection 3 of this section 11B, means related to the black box applications, to be made shall be within the 48 months from the priority date, if applicable, or the 48 months from the filing date. The same period will be there, but the language will be little bit changed, that from the priority date, if it is there, then from that the 18 months will be started, or if the priority date will be not there, then from the filing date the 48 months will be counted. Then in the third provision, the request for examination under the subsection 4 of the section 11B shall be made within the 48 months from the date of the priority or the date of the filing of the application, whichever is the earlier, or within the 6 months from the date of the revocation of the secrecy direction, whichever is the later. So in this case, the later dates will be considered because the revocation of the secrecy direction will be take time. So in that, as I have told, that 6 month period they have given. One is the 48 months. If before that, if the secrecy direction has been revoked, then the applicant can apply for the request for examination within that period. But if that period has been already passed, then within the 6 months from the date of the revocation of the secrecy direction, person can apply for the request for the examination. Then in this further provision, the request for the examination of the application is filed according to the explanation under the subsection 3 of the section 16, means section 16 is related to the divisional application. So in that, how you can apply for the request for examination, because divisional application you can apply after the main mother patent, right? So once you are applied for the divisional application, then what is the examination scenario for that request for examination timeline? So in that, made within the 48 months from the date of the filing or from the date of the priority of the first mention application, or within the 6 months from the date of the filing of the further application, whichever is the later. So this is similar to the secrecy direction only. If you have applied for the divisional application by your own self or by the wish of the controller to overcome the objections of the unity of the invention. So in that case, if you have applied your division application after 4 years or the 48 months, then you have to file the request for examination within the 6 months from the date of that divisional application, filing date of the divisional application, or is the earlier than that, the 48 months is the same like the ordinary application. Then in the next, provide for making the request for examination under the section 11B of the applications filed before the first day of these things, means the black box application under the 11B before the commencement of this Act 2005 or the period under the rule whichever is expires later. So in that case, if this 2005 rule will be commenced, or the period which we have given into the rules for this black box application, in out of that both the timelines, whichever is later, based on that the request for examination has been filed. Then in the subsection 2 or subrule 2, where the request for examination has been filed under the subrule 1 and the application has been published under the 11A, control shall refer this is related to examination receipt process, so that we will see after completion of this section related to the examination. So in this section 12, which is related to the examination of the application. So in that subsection 1 of the section 12, when the request for examination has been made in the request of an application for a patent in the prescribed manner under the subsection 1 or subsection 3 of the section 11B, the application and the specification or the other document related to thereto shall be referred to at earliest by the controller to the examiner for making the report to him in respect of the following matters they have given, right? So once the request for examination has been filed, so based on the Q number, the application, your application has been allotted to the particular controller or particular examiners by the controller to make the report. Report means the first examination report. Now, in that they are covering some of the points, the whether the application or the specification or the other document relating thereto are in the accordance with the requirement of this act or and of any rules met thereunder. So first they have checked the requirements of the law as per that they have applied within the particular time limit they have applied in the particular form or not, the form is filed that is correct or not, the fees they have paid is correct or not. So by that way they have to first check. Then whether there are any lawful grounds of the objection or to the grant, means if it is not a patentable, it's not novel, not inventive, not this not having industrial applicability, so that can be checked for that to preparing the report. The result of the investigation made under the section 13 that is related to the previous publication and all, any other matter which may be prescribed. So any unit of invention will be there, sufficiency of disclosure, animal band, clarity or consciousness. So this type of the objections they have to first check, and based on that they will generate the report. Now in the subsection 2, the examiner to whom the application or the specification or the other documents referred as per the subsection 1 should ordinarily make the report to the controller within the such period as may be prescribed. So in particular period, examiner have to make the report and they have to submit that report to the controller. So now as you have all see that they have given just such period, they have not given any timeline over here, because generally the timeline which are given by the patent office for their work, for the preparation of the examination report, for the hearing, for the granting of the patent, that always will be extended or the delayed from the given timeline. So those timeline they have not given over here, they have given into the rules. And then after they are delaying the process due to the workload over there. Right. So now we are seeing the rules which are related to the examination. So where the request for examination has been filed under the subrule 1 and the application has been published. So for any to start the examination of the any patent application, there is two requirement. One is you have to file the request for examination and your application has been published. If you have applied for the, you have filed the request for examination, but your application will be not published, then your application will be not taken for the examination perspective. So this both required you have to first fulfill, and after that only your application will be taken as for the examination process. So the controller shall refer the application specification, any documents which we have uploaded or submitted to the patent office. Those all the documents will be given to the examiner for preparation of the report. Reference cell made in order to which the request is filed. So based on the queue for the filing and queue for the request for examination, both are the different. So based on the queue number, your application will be given to the examiner for the further process and for the examination. Provided that in case of the further application filed under the subsection 16, means related to the divisional application, the order of reference of such further application shall be the same as that of the first mentioned application. So they are giving the order in the same manner of the references. Then provided that such case of the first mentioned application has already been referred for the examination, and further applications shall have to be accompanied by the request for examination, and such further applications shall be published within the 1 month and referred to the examination within the 1 month from the date of such application. So generally, if you have applied for the divisional application, so in that case, that division application will be also taken taken for the examination with respect to the their first mentioned application or the mother applications. And in the second, the period within which the examiner make the report under the subsection 2 of the section 12 shall ordinarily be 1 month, but not exceeding the 3 months. So generally the 1 month to 3 months they are taking to prepare the report. And the third, the period within which the controller shall dispose of the report of the examiner shall ordinarily 1 month from the date of the receipt of the such report by the controller. So the 1 to 3 months examiner will take to prepare or generate the report. After that, control will take 1 month for the review. And in the subsection 3, okay, the first statement of the objection or the first examination report along with any document as may be required shall be issued by the controller to the applicant or his authorized agent within the 1 month from the date of the disposal of the report of the examiner by the controller. So first 1 to 3 months examiner will prepare the report, then for 1 month control will review, and after that within the 1 month they have to give the FAR issue the FAR to the applicant or the agent, provided that where the request for examination filed by the person interested. Now, if the SELSA has filed the request for examination in my case, then only intimation of such examination has been sent to the person interested. Means only the intimation is given to the SELSA that the this particular examination on which you have applied for the request for examination, for that particular application, the examination will be started, but the examination report will be not given to the SELSA. Then reply, now the examination report has been generated. Reply to the first examination report or the objection or subsequent replied shall, if any, shall be proceed in order with such reply is the received. So once you have received the first examination report or the first statement of the objection, then you have to reply those things, and if the subsequent report will be generated, then also you have to reply those reports. Then time for putting the application in order for grant under section 21 shall be the 6 months from the date of such first examination report or statement of the objection is be issued to the applicant to comply the requirements. So once your examination report has been generated or the FAR has been generated, within the 6 months of the period you have to reply. The time putting for this given into the sub-rule that can be further extended for the next 3 months on the request on the form 4 with the extension of the time for the prescribed fees and control before the expiry of such period. So to reply the examination report, the 6-month period will be there from the date of the examination report generated. So from within that 6-month period, if you are unable to reply those, give the response to that FAR, then you have more 3 months for extensive period. So for that you have to pay the advance fee, you have to pay the extra fees for per month. You have to file the form 4 for the extension, and that is allow for the next 3 months. So total 9 months, and that request you have to apply before the completion of the 6 month. So if you are today is your 6 month has been completed, then yesterday at least by latest by yesterday, you have to apply for the extension. Yeah, now this is the rule 24C. This is whole related to the expedite examination. This is the little bit latest provision, we can say that. So expedite examination for the publication, if you want to early publish your application, there is provision, right, as per the 11A. But now if you want to expedite your examination process also, so what are the provisions, who can apply for that, which are the forms, what is the timeline and all that, all the things they have given into the rule number 24C. So in the rule number 24C, expedite examination of the applications, in that the sub-rule 1, an applicant may file a request for expedite examination, that is in the form 18A. For the normal request, it's the form 18. Now for the expedite, it's the form 18A. Along with the fees, so for the request for examination, normal fees is the 4,000. For the expedite, it's 8,000, almost double. Specified in the first schedule only by the electron transmission only. So only by the e-mode or the online platform, online portal, by the way of that only you can apply for the expedite examination. There is no way if you want to apply for the expedite examination or want to file the form 18, and then there is no offline mode will be there. Duly authenticated within the period prescribed under the 24B, means the period will be the same. You have to apply for the request for examination or the request for expedite examination within that 48 months from the filing date or the priority date. Now, who are the eligible for the expedite examination? Each and every applicants are not eligible for expedite examination. So the India has been indicated as a competent international searching authority, means ISM, or elected as an international preliminary examination authority in respect to the international application. So if any international application wants to apply for the expedite examination, so two criteria are there. One, if that application is selected India as ISA or IPEA, so they are eligible. Then second, any startup are eligible, then any small entity, then that if the applicant is a natural person, or in case of the joint applicants, all the applicants are the natural person, then the applicant or at least one of that applicants is the female, right? So if the female candidate will be there, one of the applicant is also female, then they can be eligible for the expedite examination. Then any department of the government, then any institution established by the central, province and state act. This is the new institution related, they have added provisions that as per the September amendment in the September 21, all the educational institute comes under the natural person category. The fees will be the same, so they are also eligible for the expedite examination. And the any government company will be there, then any the institute wholly or substantially financed by the government. And the application pertain to the sector which notified by the central government on the basis of the request for the head of the department of the central government, provided that the public comments are invited before any such notification. Any government department, any government companies, or the approval is given by the government, central government. So those all are the eligible for the expedite examination. And the applicant is eligible under the arrangement for the processing the patent application pursuant to the agreement between the Indian Patent Office and the foreign patent office. So let's, for example, as you all know that the one patent prosecution highway is that PPH. So in that the Japanese patent office and the Indian patent office are in the agreement. So those type of the application will be eligible for the expedite examination. So this can be asked that write down the short note on the expedite examination. All they can also ask which type of the applicants are eligible for the expedite examination. Then request for examination file another rule 24 may be converted into the request for expedite examination. So if you want to convert your normal examination to expedite examination, then you can do that. By that you have to pay the difference. The 4,000 is for the normal and 8,000 is for the expedite examination. So you have to pay the remaining 4,000 rupees if you want to convert your normal to the expedite examination. And the relevant documents, if you have filed the form 18, then now you have to file the form 18A with the proof of that. If you're a female candidate, then the ID proof of that. If startup small entity, then the particular proof for that you have to submit with that. Then in the sub rule 3, the except where the application has already been published under the subsection 2 of the section 11A, or request for publication has been made under the rule 24A is already been made, and the request for expedite examination has been accompanied by the request for publication under this. So if your application is already published, then expedite examination they are allowing, or if your application will be not published, but if you have applied for the early publication request, then they are allowing your request for expedite examination. Because if you are expediting the examination, so examination always start after the publication only. So if your application will be not published, and if you are applying for the expedite, so as such there is no meaning of the expedite or the express. Then where the request for the expedite examination does not comply with the requirement of this rule, such requests shall be proceeded in the accordance with the provisions contained in the rule number 24B with the intimation to the applicant, and shall deem to have been filed on the date of this request of the expedite examination was filed. So in this case, sometime what happened if someone has not knowledge about the I am eligible for the expedite examination or not. So they have just applied for the expedite examination, but actually that applicant is not eligible as per the rule 24C. So in that case, that application is treated as a normal application, and that things will be intimated to the applicant by the controller, and the date will be counted on which the expedite examination will be applied. Then in the rule number 5, sub rule 5 of the rule 24C, the controller shall refer the request for the expedite examination along with the application and the specification or the other document to the examiner. Now the things which they have given into 24B, that how the examination process will be ongoing. Now in the 24C, they are telling that if you are applying for the expedite examination, now what is the timeline and how the procedure will be ongoing. So in that, this application will be referred to the examiner, provided that the request for expedite examination under this rule filed by the startup or small entity not been questioned merely on the ground of the startup and small entity having filed the application for the patent ceased to be startup or the small entity due to the lapse period during which the recognized by this competent authority or its turnover subsequently crosses the financial threshold limit notified by the competent authority. So they have given just that if some startup is applied for the expedite examination, and as you all know that the 7 years time limit will be there, and the almost I think 5 crore rupees turnover will be there. So in that, if those both the criteria will be crossed, then at that time control will intimate the competent authority or the startup authority that now you are not eligible as a startup as you have crossed the limit of the financially or financial turnover, or you have crossed the limit of the time. And in the sub rule 6, the period within which the examiner shall make the report under subsection 2 of the section 12, ordinarily 1 month and not exceeding 2 months. So if you are applying the normal examination, then 1 month and not exceeding 3 months. Now here the 1 month is reduced, 1 month and the 2 months. Then the period within which the control will check, that is 1 month, that is the common for the both. Then the first examination report will be given by the control to the applicant, that is in the 15 days. In the normal examination is the 1 month, so the 15 days is also deducted here. The reply is the same, that you have to reply for the particular period. That period will be the 6 months, that can be extended further 3 months by using the form 4. Then control said dispose the application within the period of the 3 months from the date of the receipt of the last reply. So if you have applied for the last reply of the first, within that 3 months of the period, they have to give the respond. Or the hearing will be there. So after the hearing or the submission, written submission, after 3 months, they have to dispose your application, either reject or the refuse or accept. Notwithstanding anything contained in this rule, the control may limit the number of the requests for the expedite examination to be received during the year by the way of the notice to be published in the officer's journal. So generally, as such, there is no limit is given for the expedite examination request. But if sometimes a more expedite examination request has been filed, so the control may give the notice that now only this number of the applications are allowed for the expedited examination. So after that, if anyone will be applied for this, so that is not allowed for the expedited examination. So this is all about the examination. Anyone have any question in that? Okay, so before starting anticipation, we will first go through the division patent application and the patent of Addison, because this anticipation related chapter is little bit long. So first we will see the divisional application. So section 16, which is related to the divisional application, the power of controller to make order respecting the division of the application. So generally, divisional application has been filed by the direction given by the controller only. So if your application having two unique features, or your research or the invention having the product, unique product as well as the unique process. Now, if you are writing the both the things into the one patent application in the multiple independent claims, either product and the process, so in that case, it not fulfilling the criteria of the unity of invention. Unity of invention means the single patent application is allowed for the single invention. So if you are come up with this unique product and the unique process, so both are the different inventions. So for that, you have to file the different patent application. But if you have filed in the one application, then you are not fulfilling criteria of the unity of invention, and control will tell you for the division of that your application. So generally, control will give the direction for the division 90 in the 90% cases, but in the 10% cases, that applicant can also file for the division application by him or her own self. So what are the things they have given over here? A person who has made an application for the patent under this act may at any time before the grant. So before grant, any time the applicant can apply for the divisional application. If he so desire, means by his or her own wish, or with the view of the remedy of the objection raised by the controller. So that objection will be the unity of invention. On the ground that the claim, this is the definition of the unity of invention, we can say that the claims of the complete specification related to the more than one invention. One is the product, another is the process, so both are the different. While a further application with respect to the invention disclosed in the provisional or the complete specification already filed in respect of the first mentioned application. So if you have both the things you have given into the one application, then to overcome the objections raised by the controller of the unity of invention, you have to divide your application, and that you can divide at any time before the grant of the patent. Then the further application under subsection 1 shall be accompanied by the complete specification, but such complete specification shall not include any matter not in the substance not disclosed in the complete specification filed in pursuance of the first mentioned application. So the scope of your both application, ordinary or the first mentioned application and the division application, both are the same. You cannot add any additional matter. Let's for example, now if one patent has been filed for the some particular, we have to determine some limit, the predetermined data. So in that you are using the GSM module. In the GSM module, when that limit will be crossed, you will get the notification by the way of the SMS. So that is one thing. And now they have come up with some improvement or the modification, and they are incorporated the Wi-Fi module in that. So if the now Wi-Fi module will be added, so that is the different than the GSM module, and now you will getting the notification by the way of the Wi-Fi and the internet. So now both the things are different. But if you have mentioned both the things in the one patent application, and if unity of invention will be not then, and if you are dividing the if controller is giving you the direction to divide, then you can divide both the application in the Wi-Fi and in the GSM module. Second, what happened if you are by your own self, you are dividing both the application. One is with the GSM module, second one is related to the Wi-Fi module. Now that Wi-Fi word or the internet word you are not mentioned into your first mention application in the GSM module related application. So in that what happened, your scope is extended because the Wi-Fi word will be not there. So now if you are extending your scope, that is not allowed. So in subsection 2, they have told that the scope will be remains the same. The things which you have given into the first mention application, that remains as is, it is in this divisional application, that cannot be extended. Now in the third, control may require such amendments. So you can do amendment by the way of the correction or the explanation. You can give the more details into the divisional application, but you cannot extend the scope. For this purpose of this act, the further application and the complete specification accompanied, it shall be deemed to have been filed on the date on which the first application has been filed, and the further application shall be proceed with the substantive application and examine, as we have seen into the examination portion, that if the division application has been filed under section 16, then that can be examined subsequently with the mother patent or the first mentioned applications. So this is all about the division application. Division application act as an independent patent. We have to pay the renewal fees for that, and that can be applied anytime before the grant. Is there any question with respect to this divisional application?
Ma'am, there is a question in the chat box.
Okay, yeah, just now I got it.
Okay, ma'am.
But you can speak to them, it's good because
Yeah,
there is
sure.
a small window over here.
Is there examination required for the same?
For the division application?
Yes.
Yes, for request for examination, that also you have to apply, and after that examination will be also ongoing for that, because it's act as an independent patent now. Only the similar point is that only the priority for the both the application will be the same. Otherwise, both are acting as an independent patent. Any other question? No, then we are moving towards the patent of Addison.
Ma'am, I have one question.
Yes, please.
Yeah. First, if we file a patent of Addison, and then we file PCT, international sorry, first we file simple application, ordinary, and then we file a PCT application, and then controller say about the patent of divisional. So in same way in PCT we divide the application, or different process?
No, in that is from PCT there is not a granting platform, right? So from PCT you are going to the any other countries like US, Europe, or any other countries. So their patent law will be the different, as not similar to the Indian patent law. So if the Indian Patent Office has told you that you have to divide, then you can divide over here by the direction given by the controller. But if in the other country, if they have not given you the direction to divide, then you cannot. If they will told you that you have to divide those applications, and then only we are granting you the patent application, then you have to divide. But by your own self you cannot divide those things. Or if you want to get a more patent number, that I have filed the multiple patent applications, so for that also you can apply for the divisional application over other country, in the other countries.
Okay, thank you.
Okay. Any other question? Okay, so now we are moving towards the patent of Addison. So this is also the one type of the patent application. Sometimes in the patent is an exam or in your PGT IPR exam also, they will ask the short notes about the type of the applications. So in the type of the application, you can write down about the ordinary application, which we are normally filing. Then second is the patent of Addison. Third one is the patent of the divisional patent application. And fourth one is the conventional application and the application which are filed under the PCT. So you have to write down about the whole the 5 applications, which are the different types of the patent applications. So now in the patent of Addison, the section 54 to 56 are related to the patent of Addison. In that, the patent of Addison, subsection 1 of the section 54, the subject to the provisions contained in this section when an application is made for the patent in respect of any improvement or any modification. So if after filing your patent application or after grant also, if you are come up with some modification or the improvement which having the novelty but not having the inventive step. So if only you have a improvement which having the novelty, only the novelty, then you can apply for the patent of Addison, and that is for the improvement or the modification. So the invention disclosed in the complete specification as a main invention, we can say that it's a main invention or the mother patent. An applicant also applied or has applied for the patent for that the invention or the patentee in respect thereof controller may, if the applicant is request, grant a patent for the improvement or the modification of that patent of Addison. So the generally, if the applicant, if the patent application is still in the examination stage, yet not granted, so that applicant or the patentee, of if the patent will be granted. So if the patentee or the applicant can request the controller that I am applying this, filing this patent of Addison for my improvement in the modification of my particular mother patent. So for that, controller can grant those things, that patent application. Subject to the provisions contained in this section, when the invention being an improvement or the modification of the another invention is the subject of the independent patent, and the patentee is respect of the patent and is also the patentee in respect of the patent of the main invention, the control may, if the patent is so required by order, revoked of the patent of the improvement or the modification, and grant the patentee a patent of the addition in respect thereof bearing the same date of the patent has been revoked. So generally, if the same person has filed the both patent, one is the normal patent, second one is the for the improvement, but they have applied for the independent patent, not for as a patent of Addison. Now if any of the one patent or the patent for the improvement or the modification will be independent, so they can tell the patent office that if control will patent will request to revoke those patent, that independent patent for the improvement, and they can convert those independent patent to the patent of Addison. So that provision also can be available if the same applicant or the same patentee has applied both the application for the improvement. One application is for the improvement, one is for the mother patent or the main invention. Now that independent patent is revoked, revoked, or the patentee can want to revoke this patent application, so they can request to the control that please revoke this application and convert this application to the patent of Addison and give the same date of that main patent application, a patent application for the main invention to this patent of Addison. Then the patent shall not be granted as a patent of Addison unless the date of filing of the application was the same or the later than the date of the filing of the application respect to the main invention. So let's, for example, today I have filed the main invention application for the main invention or the mother patent on the 9th of the April. Now, if I want to file the patent of Addison, so that always be the same date, means the 9th of April or after that only, because the before that date is not acceptable, because the mother patent will be filed today, so the child patent will be always be afterwards, not the before. Then the fourth one, a patent of the Addison shall not be granted before the grant of the patent of the main invention. So the always first main invention will be granted, and after that only the patent of Addison will be granted. So this whole the sentence they will, I will be asked into the patent as an examination, that they will change over here, the before it will be granted, after it will be granted, it's not granted after, it's granted before, like that. So they can change over this, but the whole sentence they generally they will ask in case of the patent of Addison. Then coming to the section 55, which are related to the term of the patent of Addison. So general for the ordinary application is the 20 years, right, from the filing date or the priority date. Now for the patent of Addison, what is the term? The patent of Addison shall be granted for the term equal to the patent for the main invention. Means the similar term is given to the patent of Addison, that is the 20 years, or not much thereof to be expired, or shall remain in the force during the term or until the previous seizure of the patent for the main invention or no longer. So the generally the filing date of the main invention, from that the term will be started for the both patent of Addison as well as the patent of a normal main invention patent, because the patent of Addison is filed for what? It's filed for the to secure the priority of the main invention only. That's why it is filed as a patent of Addison. So the term will be started from the first filing date of the mother patent. And if that period will be expired, or your mother patent will be no longer, it's seized or the revoked, so in that case the term will be remains the same, but in that case that for the patent of Addison, the renewal fees now you have to pay. That is given into the in the subsection 2. No renewal fees has been payable in respect to the patent of Addison. In case of the divisional patent application that will be filed before the grant of and in the patent of Addison we can file anytime before or after grant. Then in the patent divisional application we have to pay the renewal fees regularly because it act as an independent patent, while in the patent of Addison there is no need to pay the renewal fees. But if your main patent or the patent for the main invention has been revoked, then you have to pay the renewal fees for this patent of Addison, because now it's become act as an independent patent. Then coming to the validity of the patent of the Addison, so in that the grant of the patent of Addison shall not be refused, or the granted patent of as a patent of Addison shall not be revoked or invalidated on the ground only that the invention claimed in the complete specification does not involve any inventive step. So if the invention does not having the inventive step, on that ground the patent cannot be rejected or the refused, or cannot be revoked or invalidated, because as we have learned in the first sentence that for the patent of Addison only novelty criteria is must. If there is the inventive step, then it's good. If not, then also it's okay. But that criteria, inventive step, lack of the inventive step is not the ground for the revocation or the invalidation of the refusal of the patent application. The main invention described in the complete specification, that too, and any improvement or the modification of the main invention described in the complete specification of the patent of Addison of the patent, the main invention for the patent of Addison. So in generally the validity of that patent of Addison is not challenged by stating that the ground of the inventive step. And for the removal of the doubts, it is hereby declared that in determining the novelty of the invention claimed in the complete specification filed in personal application for the patent of Addison, regard shall have had also to the complete specification in which the main invention is described. So in general, the novelty is must for the patent of Addison. Other than that, if there is lack of the inventive step, that cannot be act as a ground for the validity challenge for that particular patent of Addison related applications. So this is all about the patent of Addison. Is there any question in that?
In the case of that is term of patent of addition 54, that a patent shall not be granted as a patent of addition unless the date of filing of the application. So यहाँ पे whether it is considered as a complete specification or provisional specification also?
No, patent of Addison is filed as a complete specification only.
Okay.
So in that will be the date of the patent of Addison will be always the after the mother patent, because generally in the general scenario baby cannot be come out before the mother's birth, right? So similar principle is applicable over here. So first mother will be born, after that only the baby will be born. So in the mother patent first will be filed, and after that only the baby or the child patent will be filed.
But it must be a complete specification.
Yes. Any other question? Salja, may I continue with that, or is there any provision to take a break or like that?
Yes, ma'am, we can have break for 5 minutes. We can
Okay, okay.
continue at 4 o'clock.
Okay, because this is a law related thing, so it
Yeah,
may.
we can have a break for 5 minutes and then we can start.
Okay, okay.
Yeah. Ma'am, we can start whenever you are ready.
I'm ready.
Okay.
Okay, then. This anticipation related screen is visible, right?
Yes, ma'am.
Okay. So from the section 29 to 32, which are related to the anticipation. And what do you mean by the anticipation? So anything which are already known, already published, already in the public domain by the way of the public use, prior use, and like that. So those become as a anticipation, or we can say it's act as a prior art for your particular invention or the patent applications. So in this, they have given which become as a prior art or the who can anticipate your patent application. But with that also, they have given some of the remedies, how you can come out of that those type of the prior arts. So those things they have given over here in the section 29 to section 32. So in the section 29, that is anticipation by the previous publication. So if any publication will be there, either it's a review or the research, which is or any of the patent application which is published. So those having the similar scope, similar criteria like that of your patent applications or the features like your patent application, then how you can deal with that. So that is related to the previous publication. So in that, the subsection 1 of the section 29, an invention claimed in the complete specification shall not be deemed to have been anticipated by the reason only that the invention was published in the specification filed in pursuance of an application for patent made in India and dated before the 1st January 1912. So if any published patent will be there, which published before the 1st January 1912. So if something which are disclosed in those patent application which is published before the 1st January 1912, so those applications are not taken as a prior art for your applications. So this is the first thing which is related to the patent publication only, and that patent publication that is also in India. So generally, if we see the definition of the priority date or the prior art, so it is that anything which is discloses your patented features or your the features of your invention either in India or in the elsewhere in the world, it's in the form of the patents or the publication or the prior use. But anyhow, if something will be disclosed already, then it becomes as a prior art. Now here what they are specifying that it's a patent application only and in India only if they have published before the 1st January 1912. So they cannot taken as a prior art. But if the article will be there and that will be published before this date, then that can be taken as a prior art. If the patent application will be there, that will be published in before this date and in the outside of the India, then it also can be taken as a prior art. But the patent application and in India before 1912, if it is published, then it is not taken as a prior art. The subject to herein after provided an invention claimed in the complete specification shall not be deemed to have been anticipated by the reason only that the invention was published before the priority date of the relevant claims of the specification if the patentee or the applicant for the patents prove. So if the features is already published in anyhow, any form, patent or the publication, and based on that, no one can say that this patent, that invention is the anticipated if the patentee or the applicant can prove these things. So if the things will be disclosed and the applicant or the patentee can prove these things, then they are come out from this anticipation related things. So what the clauses and what they have to prove? They have to prove that the matter published was obtained from him or where he is not himself a true and first inventor from any person from whom he is derived title and was published without the consent or the consent of any other such person. Let's for example, I am the innovator or the researcher for the particular invention. Now I have talked with some of my colleague or some of my friends regarding that invention. Now, as I have told them, so they have applied for the patent application, but actually the idea is of mine. and now they have applied for the application. So they have stolen my idea and they have applied for the patent. So if I can prove that those things, or I can prove that that I am the that person who has applied for the patented application, that that person is not the true and first inventor. So if I can prove those things, then that particular published thing is not become as a prior art, or they not become act as an anticipation. Sorry. And in the second clause, where the patentee or the applicant for the patent or any person from whom he derived the title learned of the publication before the date of the application of the patent, or in case of the conventional application before the date of the application for the protection in a conventional country, that the application or the application in the conventional country, as the case may be, was made as soon as reasonably practicable thereafter, provided that this subsection shall not apply to if the invention was before the priority date of the claim commercially worked in the India, otherwise than for the purpose of the reasonable trials either by the patentee or the applicant for the patent or any person from whom he derived the title, or by the other person with the consent of the patentee or the applicant for the patent or any other person to whom he derived the title. So basically what they are telling, if those things which are not in the commercial perspective, if you are using those things, but that is you are, the other person is you or you are using that things is known for the reasonable trials only, or the patentee or applicant for the patent or any other person whom he derived the title for that, or learned the publication before the date of the application, or in case of the conventional application they have applied. So in general, if you can prove that I am the true and first inventor and some other person has stolen my idea and applied for the patent, if you can prove that, then that publication not become as a prior art for you. Then in the subsection 3 of the section 29, where the complete specification is filed in pursuance of the application for the patent made by the made by the person being a true and first inventor or the deriving a title from him, an invention claimed in the specification shall not be deemed to have been anticipated by reason only of any other application for the patent in respect of the same invention made in contravention of the rights of the person, or by the reason only that after the date of the filing of that other applications, the invention was used or the published without the consent of that person by the applicant in respect of that the other applications, or by any other person in consequence of the disclosure of the invention by the applicant. So in general, what they are telling in the previous publication, that things will be published before your application filed, right? But in those case, if you are the true and first inventor, you have disclosed your things to some other person, that person has filed a patent application, or they have he has published your things into the newspaper or any other article format, right? So those things, if you can prove, then you can come out of these things. If you cannot prove, so that then that become as a prior art for you. That is related to the previous publication. Now coming to the section 30, anticipation by the previous communication to the government. So an invention claimed in the complete specification shall not be deemed to have been anticipated by the reason only of the communication of the invention to the government or any person authorized by the government to investigate the invention or its merits, or of anything done in the consequences of such communication for the purpose of the investigation. So if you have applied for some grant and like that, and for that, if any government authority or the person authorized by the government is checking for your invention, so in that case, as you have communicated with them, with the government, that I have developed this thing, and as they have come to inspect those things, so you are disclosing your things to them, right? But in that case, they are not act as a prior art for you. Then third one is the related to the anticipation by the public display, that is covered under the section 31. So an invention claimed in the complete specification shall not be deemed to be an anticipation by the reason only of the display of the invention with the consent of the true and first inventor or the person deriving the title from him at the industrial or other exhibition to which the provisions of the sections have been extended by the central government by notification in the official gazette, or the use thereof with the consent of the purpose of such exhibition in the place where it is held, right? So generally what happen if we are taking example of the Vibrant Gujarat. So in the Vibrant Gujarat, if someone is exhibiting or displaying their innovation by the way of the any product or the device or the some like that, right? So if they are presenting their innovation to the government or the some exhibition to get a grant or to get some benefits, right? So in that case, those things are not act as a prior art or do not become act as anticipation. Second, the publication of the any description of the invention in the consequences of the display or the use of the invention at any such exhibition as foresight. So generally, in any exhibition, mostly related to the government exhibitions, like I have told that the Vibrant Gujarat. So if you have disclosed things over there, so that not become as a disclosure into the public domain from your side. Then in the third, the use of the invention after it has been displayed or the use at the any such exhibition as aforesaid or during the period of the exhibition by the any person without the consent of the true and false inventor or the person derived from him, or the description of the invention in the paper read by the true and false inventor before the learned society or published with the consent in the transaction of such society. So one, they have display their things in the some exhibitions. Second, they have published something into the exhibitions. They are no model, they are not presenting model, but they are publishing the things over there. Third, if you any other person who is already available into the exhibition, he will talk with you and come to know about your invention, and after that he is applied for the, use the invention or he has published those invention. Then that other person you have applied for the paper to the learned society, right? So in any of those things, that is known as the public display. If the application for the patent has been made by the true and false inventor or the person deriving the title from him not later than the 12 months after the opening of the exhibition or the reading the publication of the paper, the case may be. So here they have given the grace period, we can say that. So the 12 months grace period will be there from the date when you have exhibit, you have displayed, you have published anything which are in the public domain. If you did those activities, and from that date to the 1 year period, 12 months period in between, if any time you can apply for the patent, then those things are not act as a prior art or not act as a anticipation. But if you have applied patent after 1 year or the 12 months from the such activity, then it acts as a prior art. Then coming to the section 32, the anticipation by the public working. An invention claimed in the complete specification shall not be deemed to have been anticipated by the reason only that any time within the 1 year before the priority date of the relevant claims. Means here also they have given the 1 year grace period. So before 1 year means when you have applied for the patent, before that 1 year, if the things will be publicly worked in India by the patentee or the applicant of the patent or any other person who derived the title, or by any other person to whom consent with the patent and applicant for the patent who derived the title. So if the working was affected for the purpose of the reasonable trials only, and if it is was reasonable necessarily having the regards of the nature of the invention, the working of for that purpose should be the affected in the public. So let's, for example, we are taking the example of the civil engineering related any research work. So if some new component or new composition they have prepared by which they are preparing the roads. Now to prepare roads and to check the strength of that component or the composition which they have prepared, like some unique cement they have prepared or the dammer they have prepared, and they are applying to the on the roads and they are taking checking the strength for that. So now for that the trials will be must, and the trials are obviously in the public domain only, because in their home they cannot make a road over there and they can check the strength of that. So for that, if you have to take some trials, that is a mandatory, and that trial will be taken in the front of the public, because road is the public in the public place only, right? So in that case, if you have taken the trials and that are for the reasonable trial, not for the commercial purpose, means not if you are not generating money from that. So in that purpose, if the only reasonable trials are there, and after taking the reasonable trials within the 1 year of the period, if you have applied for the patent application, then these trials are not act as a prior art for you. Then in the section 33, the anticipation by the use and the publication after the provisional specification. Now, when you have applied for the provision application, after that, if any publication will be there and the use will be there. So in that case, what is the scenario? So where the complete specification is filed or the proceed with the pursuance of the application which was accompanied by the provisional specification, or the complete specification filed along with the application is treated by the virtue of the direction of the subsection 3 of the section 9. As I have told that the provisional and complete specification related things are given in the section 9. So as per the subsection 3 of the section 9, we are converting the complete to the provisional, right? So the one thing is the original provisional, pure provisional application will be there, which you have applied. Second is the converted provisional application, which you are converting from the complete to provisional. So in that case, now notwithstanding anything contained in this act, the controller shall not refuse to grant the patent, and the patent shall not be revoked or invalidated by the reason only that any matter described in the provisional or the specification treated aforesaid as a provisional was used in India or published in India or elsewhere at any time after the date of the filing of the specification. So if you have published your things in the any journals, you have taken any trials for those things after your provision application, so that cannot be used as a validity challenge, or that based on that the patent cannot be revoked or the invalidated, because you have secured your priority by filing the provision application. Then in the second, where the complete specification is filed in pursuance of the conventional application, because in the conventional we cannot file the provisional directly, we have to file the complete. So then, notwithstanding anything contained in this act, the controller shall not refuse the grant of patent, and the patent shall not be revoked or invalidated by the reason only that any matter disclosed in any application for the protection in the conventional country upon which the conventional application is found to used in India or published in India or elsewhere anytime after the date of the application for the protection. So if you have secured your priority, then after that any publication or the public use will be there, then it not act as a prior art. And if the before thing will be there, if the after, then it's not acted because you have secured the priority. But if the before your filing of the provisional application or the complete application, if something will be there and that window will be 1 year, and within that 1 year period, if you have filed the patent application, then also it not act as a anticipation. Now in the last section of this anticipation, the section 34, no anticipation in circumstances are only as described in the section 29, 30, 31 and 32. So other than the after provisional specification, if anything will be there into this section 29, 30, 31 and 32, if you have displayed your things, if you show your things into the exhibition, if you have published in the exhibition, if you have taken public trials, or if you have published before filing your patent application. So in that, if you have filed the patent application in the grace period, then it not act as an anticipation or not act as a prior art. If you are not filed within the grace period, then it's act as a prior art for you. So this is all about the anticipation, and with that we have completed all the four or the four topics which we want to cover today's session. So anyone have any question in these four topics also, and other than that also, if anyone have any query with respect to the patent law or the patent examination? Anyone have any question?
Any questions regarding anticipation or the sections which was covered in the session?
Other than that also, if anyone wants to ask any question related to the patent law or the patent exam or the PCT IPR related course, so they are feel free to ask.
Ma'am, I have a request. Can you just discuss the forms and the fees which are required relevant to the sections which was covered?
Particular to these sections or the overall forms and fees?
Overall also would be okay. So
Okay.
that a quick recap to all the forms and fees which are relevant to the Patent Act.
Just a minute, I will just open those things and then share the screen. The forms are visible to all you, right?
Yes.
Yeah. So in that total 1 to 30 forms are there, which are used for the different purpose. So in that the form 1, which is used for the application for the grant of the patent, means the if any this is the preliminary or mandatory form in which we have to give the basic details about the applicants, details about the inventor and title. Then the form 2 related details, how many pages are there, how many drawings are there, how many claims are there, whether we have applied for the PCT application or not, whether we have come to the India by the way of the conventional or the PCT. So the everything which are the basic details about your invention, not your invention, but basic details about your patent application, that will be given into the form 1. Then in the form 2 is the provisional or the complete specification that we are using at the time of the drafting of the patent application. So the form 2 will contain each and every details about technical details about your invention, from the starting from the first day of your research to the last day. Every data, every procedures, everything, graph, every figures, everything will be added into the form 2. Then in the form 3, that is related to the statement and undertaking under the section 8. So as per the section 8, we have to inform the patent office. Every 6 months, we have to inform the patent office that whether we have applied the similar invention into any other country or PCT or other than India, if we have applied or not. If we are not applied, then also to write down the not applicable or not applied. But you have to intimate the patent office every 6 months. So for that, the form 3 will be used. Then for the form 1, the fees will be for the natural person. I'm telling about the fees. So for the form 1, the fees will be for the online mode, and for the natural person or the startup, small entity or the educational institution, for that the 1600 fees will be there. Form 2, there is no fees. If you are filing the page more than 30, then per page you have to pay the 160 rupees. And if you are filing the drafting the claims more than 10, then per claim you have to pay the 320 rupees per claim. Then for form 3 also there is no fees. For form 4, so that is used for the extension. So if anything which you want to extend timeline, like in the FERA response, if you want to extend for the next 3 months, then if you want to extend your timeline for the renewal fees payment, so that everything where the extension will be required for that form 4 will be used, and that 4 form fees related to the form 4, that will be a vary, because if you are applying for the extension into the request for examination, then form fees will be vary. If you applied for the renewal fees payment extension, then the fees will be vary. So for that, the different fees which are given into the first schedule over here. So you can refer those whole table to remember the extension related fees for your practical point of view, because in the patent examination they are not directly asking for the what is the fees for the form 4, what is the fees for form 5, like that. But if they have asked for some scenario based question, or they have asked for some short notes like the restoration of the patent applications, for that which form will be used, if you remember the fees, then you can write down over there, so it will give you the more marks. Then the form number 5, declaration as an inventorship. So if the inventor and applicant both are the different, then inventor have to declare that I am giving my rights to the applicant, as applicant is filing the patent application, right? So for that, declaration from the inventorship is given. That there is also for the form 5, no fees will be there, and that generally we have to file with the complete specification. And with the complete specification, or within the 1 month of that complete specification, you have to submit the form 5. Then form 6, claim or request regarding any change in the applicant for the patent application. So if the after grant, if you want to change in the applicant name, then you have to apply by the way of this form 6. Then form 7, that is a notice of opposition. So this 7 will be used for the pre-grant opposition, then 7A representation for the opposition to the grant of the patent. Sorry, the 7 will be used for the post-grant opposition, and this is to the grant of patent, means the pre-grant opposition, 7A. Then Form 8, request or claim regarding the mention of the inventor name as such in the patent. So if you want to add any additional inventor name, then you have to use the Form 8. Form 9, as I told, is used for the early publication. Form 10, application for the amendment of the patent if patent will be granted, and after that, after grant, if anyone wants to amend due to some court related process or revocation or invalidation process, so for that the Form 10 will be used. Form 11, used for the application for the direction of the controller if the more than 2 owners are there, co-owners are there in the patent application, and in this regard same any dispute will be there. For that, if you want to get want any direction from the controller side, then Form 11 will be used for that. Form 12, the request for the grant of the patent under section 26(1) and 52(2). So if opposition proceeding will be ongoing, in that the wrongfully obtained the invention, in that case if the true and false inventor will want to patent on her or his name, so for that they can request and by using the Form 12. Then Form 13, application for the amendment of the application for the patent or the complete specification. So as even if anything which you want to amend into your patent or the complete specification by the way of the CD, the correction, disclaimer, and the explanation, then you have to use this Form 13. Form 14, used for the opposition, not the pre and post grant opposition, but the other oppositions which are other than the pre and post grant, like someone has applied for the surrender, someone has applied for the compulsory license, restoration. So for that, if anyone wants to oppose, so they can use the Form 14. Form 15 is used for the restoration of the patent. Form 16, application for the registration of the title or interest in the patent, or the share in the registration of the any document, means that is related to the proprietorship related things of any patent. So for that, the Form 16 will be used. Form 17 will be used for the compulsory license. 18 will be used for the request for the examination. 18A for the expedite examination. 19 is used for the revocation of the patent for the non-working. Then 20 will be used for the revision of the terms and conditions of the license. 21 used for the termination of the compulsory license. 22 will be used for the registration as a patent agent. Once you will clear the patent agent exam, then you have to file the Form 22 to register you as a patent agent. Then Form 23 for the restoration of the name of the patent agent in the register. As you all know that after registering as a patent agent, every year we have to pay the renewal fees for that. So if we will forgot to pay the renewal fees, then we have to for that we have our name will be removed from the register, and for that we have to pay the extra fees in the with the Form 23 to restore our name into the patent agent register. Then in the 24, controller review setting aside the controller's decisions. So if any decision will be there, again you want to review those things, so for that you have to request the controller to review again. Then in the Form 25, that is used if you want to directly file into the outside of the India patent application, that you have to take the first permission from the patent office that I am directly filing the patent application into the any other country other than India. So for that, Form 25 will be used. Form 26 is the power of authorization. If you are hiring any patent agent, or now you all are becoming a patent agent, the near future. So if some client is hiring you, so for that the Form 26 will be used. Form 27, every year we have to give that the working of the our patented invention, whether it's workable at a commercial scale or not. So that every year we have to inform the patent office, like the Form 3. Every 6 months we have to inform. Then Form 28, form for to submit by the small entity, startup, or the now the educational institution. Form 29, if you want to withdraw your application, so for the request for the withdrawal or the request withdrawal of the request for examination, that can be withdrawn by the Form 29. And Form 30, if any form is not available, then Form 30 will be used for that use. So this is all about the forms and fees. For that, you have to remember the individual fees only. And after that, you can just exit the calculation. I didn't remember, but you can you have to multiply some time, and based on that, you will get the exact answer for the each and every fees. So you have to just remember this one. And after that, you can multiply and get the answer for the others category. Okay. Now, anyone have any question in?
Ma'am, if a patent for the main invention is revoked, and in that case, the patent of addition may continue as an independent patent for the remaining part of
Yes, yes, it
patent.
may be act as an independent patent, but for that, when the main patent will be survive, right, or enforced, at that time we no need to pay the renewal fees. But now, if the main patent will be revoked and your patent of addition is survived, then you have to pay the renewal fees to keep your patent of addition as a enforce.
Okay. And ma'am,
Now your patent of addition act as independent patent only.
okay. And if the main patent is not yet granted, then the patent of addition will not be granted, right?
Yes, yes. First main patent will be granted because the patent of addition is only the improvement of the main invention.
Yeah.
So first that will be granted, and after that only the patent of addition will be granted.
Okay. Any doubts from the participants regarding the sections or anything regarding patent agent exam preparation? Okay, ma'am. Then I think we'll end the session because there is no any doubt.
And afterwards also, anyone have any queries? So you have my mail ID, so you can collect the question and send to me. And I think I have also shared my mail ID and number when I have come earlier for the drafting session. So directly anyone can ask me, or by via you anyone can ask.
Okay. So I would now request all the audience to kindly on their camera for a quick photo. All the participants, please on your camera. Okay, thank you so much, ma'am, for your time.
Thank you, thank
Thank
you.
you so much. Have a great day, ma'am. Bye.
Yeah, thank you, and all the very best to all of you. Now only the 1 month is there for the patent examination.
Thank you so much. Thank you.
Okay.
Thank you, ma'am.
Bye-bye. Yeah, thank you.
So all the participants will be meeting tomorrow at 10:30.